Senator Levin.
Thank you, Mr. Chairman. First, I have two requests of our chairman before I ask my questions. One is I would request that there be a redaction and then a release publicly of both the Phoenix Memo and the Minneapolis documents. I made a request many months ago, back in May or June, for the public release after redaction to protect sources and methods. The letter I got back from the FBI was that they hope to do this at some point in the not-too-distant future. It is still not done. It is an essential part of our investigation. I believe that the documents with proper redaction be released publicly. Without that, accountability is less likely. So I would ask the chairs to take that under consideration. Secondly, I'd like to highlight a portion in the staff report this morning on page 23, where near the bottom of the page it says that a CIA officer detailed to FBI headquarters learned of the Moussaoui investigation from CTC in the third week of August. The officer was alarmed about Moussaoui for several reasons. Those reasons are stunning quotes, if I can put it that way, from documents which I can't see any reason not to be released. And I would hope that the chairs and the vice chairs would get together and see whether or not we cannot get the disclosure of those quotes from the documents referred to. This was when the CIA stations were advised of the known facts. That's the next line. All I can tell you is that the reference there are to specific decisions, findings made by that officer, which were directly relevant to this investigation and to these events. So I would ask that our chairs take that under, if they would consider that request as well.
That request has in fact already been made, and it is a work in process. I'm not sure how it is going to come out, but you will be advised.
And the first one as well?
Yes, sir, both of those.
Thank you. Third, now the questions. And this would be for our headquarters agent. The Phoenix FBI agent recommended that FBI headquarters, quote, should discuss the concerns raised by the agent in the Phoenix memorandum with other elements of the U.S. intelligence community and task the community for any information that supports Phoenix suspicions. I gather that was not done. Is that correct? And if so, why not briefly?
I've learned, obviously, post 9/11 of some of the actions that were taken both by the field and by the analysts. In fact, it's my understanding that our Phoenix division had, in fact, discussed a number of the subjects, in fact, maybe all of them, and maybe my colleague could comment on this also, with the CIA, and at a couple of meetings, the issue of the infiltration of the airline industry by terrorist subjects was discussed.
All right, so therefore you're saying that the headquarters, your unit, did in fact discuss the concerns raised by the agent with the intelligence community. Is that what you're saying? You acted on that request?
No, I'm not. I'm saying.
Why did you not act on that request?
I can't answer that except to speak to what I learned post 9/11.
All right. Well, that doesn't then answer the question. You don't know why you didn't act on that request at the time. Is that the answer to the question?
That's correct.
Now, the next question then relates to the Minneapolis issue, which is here you've got, well, to go back to Phoenix, in the case of Phoenix, you've got an agent here who says, requests specifically that these concerns be shared with the intelligence community. You did not act on that request without, inexplicably. Now we've got another similar situation in Minneapolis. But here, apparently, the Minneapolis division did notify the CIA's Counterterrorist Center, the CTC, and according to Ms. Rowley, was, in her words, chastised for making the direct notification without the approval of the FBI. Now, let me ask our Minneapolis agent, do you know if that statement of Ms. Rowley is true?
That is true, sir.
All right. This is to me, goes to the heart of...
Excuse me, if I may qualify that a little bit. It's true to a point. The word chastised is perhaps a little prejudicial here. I did receive a communication from a supervisor at FBI headquarters that indicated his preference would be that we contact FBI headquarters to coordinate any intelligence sharing with CIA headquarters. He indicated to me that the information flowed better when they were communicating headquarters to headquarters. And I know that has been a long-standing preference of FBI headquarters.
Did you or she consider that to be a reprimand in sorts, a correction of a previous action?
It seemed to me to be a direction from FBI headquarters to cease and desist.
Cease and desist.
I'd like to speak to that if I could.
Yeah. I'll tell you, I'm out of time. And I wanted to just, I think I'm out of time.
Senator, you are out of time, but you,
Could I respond to that?
I'd yield you an additional minute because you took a minute on administrative matters, which are a benefit to all of us. So if you'd like the additional minute, it's your choice, sir.
Thank you. If you can do that in 30 seconds, that'll give me 30 seconds for my last question.
Yeah, I really can, and namely that the supervisor who was handling that matter is the person who is going to be the affiant on the FISA. That individual has to be aware of everything that is going on in that case, and communications cannot be kind of going around him. The reality of it is things do work much better when they go through headquarters. There was no effort to hinder in any manner communications between CIA and FBI. In fact, I can tell you from firsthand experience with my conversations with CIA and with our FBI representative at CIA during that time frame that there was exceptional flow of information back and forth.
There's a very quick question with the last 20 seconds. It's one thing where there's reticence on the part of agents, where there's legal barriers to take certain actions, but where there's no barriers, that's where we get into trouble, it seems to me. That's where I have difficulty understanding the failures to act. One of the great failures here had to do with the FISA warrant and what is the standard for getting a FISA warrant, and the so-called foreign power provision, which you viewed or were told was a barrier, erroneously, by the legal division at FBI. Apparently it was established by Senator Edwards. It was erroneous. Now, my question is this, and I read the law, it's clearly erroneous. You don't have to have a foreign power. You have a foreign terrorist group. That's enough for a FISA agent under the law, as it existed at that time.
The foreign power with regard to a FISA in a terrorism case would be a terrorist organization.
Exactly right. You don't need a foreign power. A terrorist organization is enough, and yet this was not pursued because it was, you were told that you had to prove that there was a foreign power connection. But
no, that's not accurate.
All right, if that's not correct, fine. I'll let Senator Edwards' Q&A answer that. My question is this. Apparently there was an acknowledgement there was a misinterpretation of the law, okay? How many FISA requests were not made based on that misinterpretation of law, in addition to the one that we're talking about here? That's a very specific numerical question. How many requests were not made based on the misinterpretation which was acknowledged or explored by Senator Edwards?
I'll very briefly answer that, if I may, Mr. Chairman. I don't know of any other instance in which something like this came up, but I don't think, Senator, that Senator Edwards' questions got quite to what you were focused on there. The fact of the matter is that the agent of a foreign power is something that is not defined in the statute, but it is addressed in the legislative history, which we have to follow because that is where we get an explanation of it. An agent of a foreign power in the legislative history describes a knowing member of a group or organization and puts an onus on the government to prove that there is a nexus which exists between that individual and the organization, which would make it likely that that individual would do the bidding of the foreign power. That is the stretch that we weren't able to get to.
Thank you.
Mr. Chairman, if I may, I think that's absolutely essential because there seems to be a disconnect between whether or not we did not get the FISA because we could not connect him to a foreign power. We did not get the FISA because the decision came out in consultation with OGC that we could not plead him as an agent of that foreign power.
If I could put in the record the definitions of foreign power in 50 U.S. Code Section 1801A, and foreign power is defined as including in subsection 4 a group engaged in international terrorism or activities in preparation therefore.
No disagreement, but we have to prove he's an agent of that foreign power.
Of that group.
Right.
Of
And that's
that
where we were
group.
lacking. That's where we were lacking, that he was an agent of that group.
If I could, this is a very significant issue, and one that we should probably take up in a closed session, and it needs to be explored because this is a problem that we're going to face many times now in the future. And this issue of how to get at these so-called lone wolves needs to be addressed.
Thank you very much. We will do that. And we have in plain text up here what Senator Levin has just held up. It's in our briefing books, and we are reading it obviously as laymen, not as operatives in the field or people having to deal with it. And obviously this needs more dialogue, and we will arrange to have it in a freer atmosphere for those of us who have to deal with this stuff. I think your suggestion is excellent.